Hi, everyone. Welcome to another episode of the Ask Amity Show. I'm Jennifer, and we're here with Cindy today, and we'd like to talk to you about a common question that we receive when clients are either about to purchase a real property or inherit a real property. So this happens when they're about to purchase and they say, "Hey, how should I title this property?" So oftentimes, if you're going to be inheriting or purchasing with other individuals, it could be with your spouse, your siblings, your children. How should the real property be titled? So two common methods that we've come across is joint tenancy and tenants in common. So first of all, what is a joint tenancy? So joint tenancy is in California is a method in which parties, generally family members or spouses, they jointly hold on to a title of piece of property. And then in joint tenancy, all co-owners hold an equal share of the property. So for example, if there are two co-owners and they're titled as joint tenants, then that means they each own 50% of that real property. So joint tenancies, what's a little bit different with it is because there is an inherent right of survivorship. So that means whoever passes away first, the remaining individual will automatically inherit that other person's share. So for instance, if there's three people, all joint tenants, and one person passes, then that person's 1/3 goes equally to the remaining two individuals, leaving them each 50% basically owners of that property. One thing we need to keep in mind is that there is still a risk of probate with joint tenants. So a lot of times, we have clients say, "Hey, that's perfect. If it's with my spouse, then my spouse will inherit if I pass, and then, we're free from probate." But you really need to make sure that, although that is true, there is a risk because what if, both husband and wife pass at the same time, there was some sort of accident or, something happens where they pass concurrently, then that property will go through probate because both joint tenants have passed. Another risk is, if one spouse does pass and, the remaining joint tenant continues to hold on to that property, but fails to plan for when he or she also passes, then that also leads to probate. So we generally do advise our clients, even though, hey, joint tenancy is good for the time being, but ultimately you do need to plan for the unexpected. So a living trust, planning for having a beneficiary listed is essential to make sure that that property doesn't have to go through probate.
And the other way to hold property jointly or together is called tenancy in common. It's just another way where parties can hold property. With a tenancy in common, the parties do not have to own equal shares of the property. For example, between two co-owners of a tenancy in common, one joint tenant or one tenant in common may own 70%, whereas another tenant may own the remaining 30%. The tenants in common does not automatically have a right of survivorship. That means that if one tenant in common passes, their share will not go to the other tenant, but instead their share will go through probate unless that tenant is a trust. Unless the deceased tenant share is held by a trust. Otherwise, their share will go through probate. So this is not a very good way of holding property rights as a tenancy in common. Again, unless it's held by, for example, maybe two trusts, then you can hold it as a tenants in common, that's fine. But typically, if it's two individuals, we don't generally recommend holding tenants in common, just because you want to make sure that if anything happens to one tenant, then something, their share will be able to be absorbed by somebody or a trust or something, so it doesn't go into probate. Probate, again, is a very expensive method, very time-consuming process. So at all costs, we want to avoid probate. Also, a word of caution is that when you're attempting to change title or severing joint tenancy or tenancy in common, any of these types of action may affect your property tax. So make sure you consult with an attorney, with a professional prior to making any title changes to your properties. Property tax can be pretty hefty, especially for properties that are very high in value. Lots of properties are very expensive here in the state of California. So you don't want to mess around with your property tax, and make sure you consult with a professional before you make any of those changes. So that's all we have for today in this episode. Hope you enjoyed it, and we'll see you next time. Thank you for watching.